Hi, good afternoon, everyone. Thank you so much for joining us today for our online talk. We will start shortly at 3 p.m. But first of all, for those who are here early, thank you so much for coming. Thank you for waiting patiently. While waiting, for those who are first time joining our talk, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you so much for joining us for today's online talk. The title of our talk today is on Legal Remedies for Unlawful Customs Department Seizures. Now, before that, my name is Yong Hao Jet. I'm a pupil in Chambers here in Ma Wing Kwai & Associates, and I will be your moderator for today's session. Before we start the talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises of 35 lawyers and a support team of 29. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. Now, we are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration. We have a dedicated employment and industrial relations team and a department focused on servicing the needs of individuals and families. Our practice group indicates some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our Ma Wing Kwai & Associates online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the recent pandemic and COVID-19 and MCO, we have since moved it online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for our clients, potential clients, and also our in-house counsels. Now, before I continue, please be reminded that this talk does not constitute any legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. We provide the details at the end of this talk. Now, moving on, allow me to introduce our speaker for today. So our speaker for today is Ms. Agalia Munasamy. She is our partner in our criminal customs and logistics, family and matrimonial teams. Her main practice areas include in advising on criminal defense strategies, anti-money laundering, corruption charges. Her areas of practice also include criminal law, general litigation, custom advisory, and seizure-related matters. Now, today's session will be broken into 4 main talking points where Ms. Agalia will be speaking on. First, she will cover on the powers of the customs officers under the Customs Act 1967. Next, it will be on the immediate steps businesses should take or could take after a seizure. Then the legal remedies and claims for damages in Wrongful Seizures Act, key cases involving RMCD, and also the judicial trend in recent years. After covering all this, we will then conclude with a Q&A session. Now, for our Q&A session, without further ado, I'll pass the floor to Ms. Agalia.
Hi, thank you for the introduction. All right, so let's get straight into it. Ladies and gentlemen, thank you for joining us. This is coincidentally Marvin Kwai's first talk on this series on customs law, and I am honored to be the speaker for this session. As Ajit has informed earlier, I will be covering these 4 talk points that you can see on your screen right now. Without much ado, let's just get into our talk today. What are some of the powers of custom officers that you might have or you might have thought you would like to ask us? Just so you know, there is a wide range of powers that is given to customs officers pursuant to the Customs Act. Let's start with general enforcement powers, which you can see on the screen. So this is given pursuant to Section 106B of the Customs Act 1967. This section provides that a senior customs officer of customs shall have all the powers of a police officer and under the Criminal Procedure Code. So this means senior officer of the customs could stop you on the road, can ask for your license, can ask for your IC, and these are the general powers that is accorded to them. And it's highly advisable to comply with their instructions, because if they're able to enforce the power of a police under the Criminal Procedure Code, that means they also have equal power to arrest you for not complying with their instructions at that time. To move into, this is a general overview of all the other powers of the customs officers pursuant to the Customs Act 1967. As you can see on the screen, I have summarized their powers of search to Section 107, 108, 109, Section 111 and 113. So they have powers to search conveyance, they have power to search goods, they have power to search your vehicles, they also have power to search your premises under these wide sections that are covered in the Customs Act. Next, we can move on to the customs officer's power to seize and forfeit. So this provision is specifically provided under Section 114 and Section 126 of the Customs Act. So this specifically tells them that goods that are seized by the customs officers are liable to forfeiture. And evidently that also means they have power to seize, which means they can take it away from you and they can store it with them in their power, in their custody, and in their control. Okay. As mentioned earlier, they also do have the power to arrest a normal person, someone that they find on the street. They can search your conveyance, they can search your car, they can search your goods, and if you refuse to comply, they can also arrest you pursuant to Section 116. Next, they also have power to inspect. So power to inspect includes power to inspect, again, conveyance, premises. They have power to inspect your records. Maybe you have digital records, you have things stored in a computer, stored in a laptop, you have stored in a mobile device. So there is power granted to customs officers to inspect all these kind of devices and also records, hard copy records that you may have stored either in your premise, in your car, or anywhere else. So having gone through the wide range of powers that a customs officer may have, what happens if there is someone you know, or whether you yourself are facing a situation where some sort of goods might be seized from your custody? So when a seizure happens, this is usually in a case where, in a lot of cases that I have handled, seizure usually happens pursuant to some sort of information that they have received. So this might be internal information, this might be confidential information that they have received. The officers might have received that some sort of smuggling is going to take place. They might identify specific vehicles that are carrying maybe contraband or maybe carrying uncustomed goods or prohibited goods. So in my general experience, seizure takes place after some sort of information is given. And as soon as the person leaves the port with the goods in their lorry, in most situations, it's a lorry or a container or a tanker or a huge carrier vehicle. So they will stop you right outside the gate of the port and they will say, okay, please get down. I need to check your gate pass. I need to check your conveyance. Can you please open the back? I want to see the behind of the vehicle, what goods you are carrying inside, those kind of things. So the first thing you have to do when you are facing this situation is that you have to confirm the legality and the basis of the seizure. So the power to seize is provided for under Section 114, and Section 114 specifically states that when a seizure occurs, a customs officer must issue a written notice of seizure, which is also known as Borang Custom Number 1 or Notice of Seizure. In most cases, it's also, which is what they will usually give you. It's very rare that they issue notice in English. Just please be aware of the different kind of wordings that they may use when it's translated into Malay language. So in this notice of seizure or borang that is issued by customs officers, they will usually state the reasons for the seizure and the amount of goods or conveyance or items that are seized. So say you are carrying 2,000 cartons of beer, whether it might be Tiger beer, Heineken beer, or different kind of brands. So they might say 2,000 carton or pelbagai jenis jenama. So they can say something as general as that. But usually the count of the goods is very important. You will know why, because there is something called chain of evidence. So whatever they seize in the notice sitaan has to be exactly the amount that they produce in the charge sheet. Even if there's a slight difference, that is already grounds for you to, it's a very good grounds to prove that there has been some sort of break in the evidence chain, which will be used in the course of your defense in the event somebody is being charged for this offense. Okay. And Section 114 provides, what if the owner is not there? Just say somebody is driving a lorry, but the lorry driver is just someone that's paid to drive a lorry. Maybe a transportational logistic company is being hired by the owner of the goods to carry these goods out from the port to maybe their warehouse, which is located elsewhere. So what happens if the owner is not present? The notice must be served to the driver, most likely to the driver. And if the owner is not known, even if the driver doesn't know who the owner is or the documentation with him doesn't prove who the owner is, it can be later served on the owner. It doesn't have to be served on the spot, but it's highly likely that on the spot during the time of seizure, the notice will be served on the driver who is maybe driving the lorry, or if it's seized in a warehouse, it might be served on the warehouse employees or things like that. But most of the time, a notice of seizure must be issued to identify what is the offense that they suspect has been committed and the number, the quantity of goods or the items that were seized. And specifically, if there are different types of goods, say maybe there is 100 cartons of beer and then there's 200 cartons of whiskey. So they have to identify all of this in detail. So apart from a notice of seizure, what will happen is they will issue a general notice of seizure. Say that perhaps in a scenario where there is too many things in a huge 40-inch container and they want to seize the container. So what happens is they will issue a notice of seizure on all the goods that is inside the container, and then they would usually supplement this notice of seizure with a borang bongkar. So a borang bongkar is also called a search list. Basically what happens is they will seize the container, they will take it to maybe a customs port or maybe a customs warehouse or customs depot, where they will then open the seal on the container before a witness, and then they will taking out all the items one by one, and they will put it together with a borang bongkar. So it may not necessarily be on the notice of seizure itself. It can be supplemented with a borang bongkar or a search list later on. So what do you do when you or your driver or somebody obtains a copy of this notice of seizure? Firstly, there is no harm in signing that notice. Signing the notice doesn't mean that you have committed an offense. Signing of the notice only tends to show that you were the person who received that notice. It does not go to show that you have already committed this offense and because of that you can be charged in the court. It's usually not like that. So don't be afraid if they say, I want you to acknowledge that you have received this notice. That's perfectly fine. You can do that. You can acknowledge receipt of a notice of seizure. There is nothing in law that says that you should not or you must not, in fear of being prosecuted later on. Okay, so you can obtain and keep the copy of the seizure notice. In circumstances where a lot of them are lorry drivers who usually don't know what's happening, you can take this notice of seizure and go back to perhaps your boss or somebody higher up who you think is usually in contact with the owner of the goods. So then through notification by your boss, or the owner will eventually find out that their goods have been seized and only the driver was in the spot. So you should keep a copy of this notice and perhaps make a photocopy, and also for your records, keep it safe so that you can have future evidence of having received the notice of seizure. Okay, secondly, what you can do, you have to review the notice and you note the date of the seizure is very important, and the description of the goods. As I said, it might not be a very descriptive list. It can be a very vague list, but it will later be supplemented with a borang bongkar. So you have to be present while they are preparing the borang bongkar. just so that you know that these are the quantity of the goods or the items that were seized from that container. And you should also know who the officer in charge is. So the officer in charge who issues the seizure notice is usually known and called as the seizing officer. So this seizing officer is a very pertinent witness. If there is a prosecution taken, the seizing officer will be called to explain what were the reasons that he effected the seizure and if there's any probable or reasonable cause in the process of the seizing the goods. And then you should also check if the seizure was based on the items being prohibited or custom good. So prohibited or uncustom goods, they are very different. Prohibited means you absolutely cannot bring it in to Malaysia or it cannot leave the free zone. And there is absolute prohibition on those items and the customs will not allow it to enter outside the free zone. So if you're talking about uncustom goods, means that goods that have not been paid duty or has not what they call lulus custom. Uncustom good is lulus custom. So this does not mean they are prohibited. Goods basically means that you have not taken the correct steps to bring them inside Malaysia. So you're not prohibited, but you have to do additional steps. Like you bringing in cigarettes, you have to pay the duty for your cigarettes. You can't just bring it in. It's not prohibited. It's not illegal in Malaysia, but it has to be, there must be duty paid on those cigarettes or beer or those kind of items. So there's a big difference between prohibited and uncustoms good. This is something that you have to look out for. But even if you can't tell the difference or you don't know what the difference is, do not worry. As long as the items are stated in the seizure notice, as I said earlier, please don't be afraid of signing or acknowledging receipt of the seizure notice. The next thing that you would commonly find in the notice of seizure is the reasons being incorrect declarations. So incorrect declaration means you have brought in an item and then you have declared it as a separate item for it to pass the customs and come outside. So if they find that there has been some sort of mismatch of goods, mismatch of description of the goods, there is a reasonable cause to stop the conveyance and to seize the conveyance. And also if there is any alleged under-evaluation or misclassification. So in the event of misclassification of goods, what you can usually do is we can write into the customs department or the classification department. They call it Jabatan Klasifikasi, and you can get a confirmation on what is the actual classification of these goods. Let's see what are the next steps you can do once you get the seizure notice. So here we have, you can file a formal claim to recover the goods. This filing of a formal claim is provided for under section 128 of the Customs Act. So basically what this means is if you claim to be the owner of any goods that is seized, whether or not you receive the notice of seizure, you can actually write in to the Customs Department or the DG of Customs for the release of the goods. And you have to assert yourself as the owner of the goods. So this claim or written claim, or what we say, must be made to the Director General of Customs or most likely to the investigating officer. Please note the difference between an investigating officer and a seizing officer. Most of the time, the seizing officer comes from operasi. And a lot of times when we go, as the case continues, if there's an investigation started on this case, or on the seizure, the file will then be passed on to an investigating officer who is usually in the enforcement department. So there are two separate departments involved here. And once you are aware that there has been some sort of investigation, the case by this point would have usually moved over to the investigating officer. And it's to the investigating officer is the person who you address your claim to. Even if you don't know who the investigating officer is, you can write into any head of department or as mentioned, Director General of Customs for the release of the goods. So this claim or whatever it is, you should assert the ownership as I mentioned earlier, even if the notice of seizure is not addressed to you, even if you are not the person who received it, or even if you have asked for the notice of seizure to be issued to you and it is refused to be issued to you by the customs officer. Okay, so nothing stops you from claiming ownership of the goods. All you have to do is send in a letter and say that on this date, this item was seized, there was this many quantity of items seized, I am the owner of the goods and I'm claiming for the release of the goods. So what happens once you make this claim? Failure to act within 1 month of getting the seizure of notice, the seized goods will be deemed to be forfeited to the government under section 1 to 8, subsection 1. So there is a timeline, a very strict timeline that you must comply with. Upon knowing the seizure, whether the notice, regardless of the seizure notice being served on you, as long as you have known about it, you have 1 month from the day that you are aware to the time the goods are deemed to be forfeited. So how do you file a claim once you know that there is some sort of seizure and you are the owner of the goods and you want to now seek the release of the goods? What do you do? So I would highly advise you to engage a lawyer to write and send in a claim promptly. Again, as I mentioned, within 30 days. The word 30 days appears in the section itself. So it's a very fast timeline that you have to work with. So you have to write in a letter within 30 days to the seizing officer or the investigating officer. What you can also do, but this is not required, this is not necessary, you could supplement your letter which asserts ownership by attaching document proving that ownership. For example, you have invoices issued under your company name for those goods, you can put that in, or you have import permits, or you have the bill of lading which is used to bring in the container to the port. You can use those documents, attach them, for not only for the purpose of asserting ownership, but also you might help out with the investigation process itself. Okay, so the key point to note here is that any person who asserts to be the owner can claim the return of the goods. This point I will expand on it later on, where you will see that the courts have held that you do not need to have beneficial ownership of the goods to actually claim the goods. You can claim the goods even if you're an agent or an authorized person who is authorized by the owner or the consignor to take control of the goods and to claim it on behalf of them. Okay, so I will explain this a bit later on. And lastly, once you do the claim, once you send in the claim, you should absolutely keep all records of the letters that you have sent and any acknowledgement of receipt by the Customs Department. This is also very important because I will tell you why. As we move on, you will know that this 30 days is actually a very important timeline. So the next thing you should do is, as I mentioned, you should cooperate with the investigation and provide the documents. So if you are, in fact, the owner of the goods that were seized, you should cooperate with the investigation. Don't disappear, because that only proves that they had reasons to seize your goods. So you have to be forthcoming, you have to be upfront, cooperate as much as you can with the investigations. And I've listed here several sections. Sections 106A, which gives the customs officers right of access to your premise, and also searching powers. So they can search, they can inspect the documents in your office, and they can do a wide range of powers that they have that they can use to obtain any information regarding the goods that they have seized. So if you're asking, like, how do I cooperate under section 106 and section 100A, how do I cooperate with the customs officers? Here you go. So you can provide the requested documents. As I said, you can provide invoices, you can provide payment vouchers, you can provide payment receipts, you can provide export-import declarations, Borang K1. If you are moving the goods from free zone to another free zone, you can declare transmission, you can declare Borang K8. So all these documents that you should have in your records, which will assist with your claim and your ownership of the goods. So please remember, do not obstruct the officers who are carrying out their duties. If you obstruct any officer who has come to your office, maybe they have come to your premise, suddenly they showed up, about 4 or 5 of them will show up, and then they said, I need to go into your office right now, I need to search your premise right now, I have reasons to believe that some documents relating to this seizure is sitting in your office, so I need to inspect your documents, I have to inspect your computer, and maybe go through your emails as well. So the issue is do not obstruct them, because obstruction of customs officers itself is an offense under section 136, and you can be arrested on the spot and taken to a magistrate on the spot because you are obstructing public officer from carrying out his duties. But however, do consult and engage a lawyer or a counsel before making any written statements to the customs officers. So whenever you are asked to cooperate with the investigation, you would be sent a notice asking you to appear in their office. This, in my experience, is usually harmless because they are just trying to take statements to ascertain whether these goods really belong to you, whether you know that these goods have come in and whether someone is fraudulently using maybe your license, your permit, or your pass. It's usually harmless because they are collecting information that will help with the investigation. But if you feel like it could be detrimental to your claim, please seek legal counsel or legal advice and go with a lawyer. So make an appointment at a later date where your lawyer can be present during the statement taking. But please note that even if your lawyer is present during statement taking, this does not mean the police cannot arrest you. This is a wrong connotation. Everyone thinks if I go somewhere with my lawyer, I'm very safe. No one can touch me. No one can do anything. So actually, this is a wrong connotation. A lawyer, even if they are authorized to represent you, they cannot stop a police officer from arresting you on the spot. Yeah, so please keep that in mind and bear that even lawyers have their limitations on what we can do, what we cannot do according to the law. So once you have put in your claim within the 30 days, right, what can you do while waiting for it? So Section 126 provides that all goods that were seized by the customs is liable for forfeiture. All goods meaning all goods subject to other sections. So these are the other sections are the things that I will continue in my talk later on. But this is a general provision. Section 126 is a general provision that provides all goods that are seized by the customs officers are liable to forfeiture. So what does it mean liable to forfeiture? Liable to forfeiture means they can just take the goods and they can do anything they want with it. So either customs officers decide they want to sell it to another party who has got authorization to bring those goods in, or a quota to bring those goods in, they can do that. So that is forfeiture. Forfeiture means they have taken over your right over that goods and it is now the customs department's rights. Right? So Section 127 then provides that court can actually order for disposal of goods that were seized. So if prosecution is initiated, the goods shall remain in customs custody until the court proceedings are completed. So at the end of the customs investigations or the court proceedings, usually what happens is even if there is no prosecution, any goods that were seized can be the court can order forfeiture or release depending on the outcome. So this doesn't mean that if you are not guilty, you are able to get back the goods. Even if someone is charged for an offense of smuggling or such things, what happens is once you prove your innocence in court, because the goods that were seized are subject to forfeiture, the court can independently order that the goods still be forfeited to the government, even though nobody is found guilty. Okay, so the next step comes to what happens if there is no prosecution. In most cases that I have dealt with, there is usually no prosecution initiated. Section 128 says that you have to make a claim within 30 days, and upon 30 days of making the claim, the Director General of Customs must either release the goods or refer to a magistrate. So when you refer to a magistrate, of course, then the above section will apply if prosecution is initiated. So referring to a magistrate means you have to prove that you are the owner of those goods in the court. But what happens if there's no prosecution? If there is no prosecution and there is no claim, okay, say within 30 days you forget to put in your claim because you're so busy with other things. So what happens then is that the custom may treat the goods as administratively forfeited, or they deem it to be forfeited. So once there is a deeming forfeiture, there is nothing else you can do to get back your goods, unfortunately. Which is why I said the 30-day time period is very important for you to put in a claim, by when the DG then will know that there is an interested person who is claiming ownership over the goods. Okay, I will just skip this slide because you can track the investigations. Of course, this is once you can check with the investigating officer, you can check with the seizing officer, but most likely it's the investigating officer. A lot of the time, investigating officers are the ones who will be dealing with you directly, either to get statements or to get documents or to carry out any sort of statements that will assist with identifying who is the owner of the goods. Then you can track with them, you can ask them to keep you updated on the progress, whether I'm going to be charged, whether there's someone else who is claiming ownership of the goods. So all these things you can liaise with the investigating officer, or if you already have a solicitor present, your lawyer also can check with them. And this at the bottom here, if the goods are perishable or time sensitive. So now we are dealing with goods that have shelf life. So a very short shelf life means you cannot keep these goods in the container for too long. Maybe it needs to be frozen. Maybe it needs to have special conditions for it to remain unaltered or remain safe for consumption. You can request for an expedited decision, although it is strictly discretionary on the Director General of Customs. There's nothing that stops you from asking for an expedited decision or provisional release. So let's recap on the timeline that we are looking at. So look at day 1, right? Your goods arrive at the port. So what happens from day 1? There will be a declaration made by the shipper that these goods are coming into the port. So this is the manifest. There will be a manifest declaration, and the shipper will usually declare the manifest saying that they are dropping these goods in the port. Then after that, you are supposed to submit your declaration forms as soon as possible to avoid any type of suspicion arising. Because I have had, in my experience, someone had seized goods on the basis that it was sitting in the port for 2 months without any action. So when someone finally tried to do a declaration on it, they seized the goods. So this is to avoid any sort of possible suspicion. The next thing you can do is, if the goods are then seized, look at the date of the seizure. So you are supposed to, if you are the owner of the goods or you are an agent that knows that these goods are being seized, or through maybe your driver or through your contacts in the customs, through your contacts in the port, that these goods were seized, right? So you have 30 days from that time to put in a claim that you are claiming the release of the goods. So this date of the seizure plus 30 days becomes day Y. Day Y is within when the customs officers have to decide, now that they see that someone has claimed for the goods, what do I do with this claim? So when they have the choice, they only have 2 choices, by the way. This is a statutory choice given to them. Once they get a notice of claim that you are claiming for the release of the goods, there is only 2 options that they can take, and this is decided by the courts. So there is no other alternative decisions that they can take. The 2 choices are, they either release the goods to you or they refer it to the magistrate for a decision. So within that 30 days, and then there's an additional 30 days by when they decide they have to release it or they have to refer to a magistrate. And if nothing is done by this time, obviously that means something is wrong with the seizure. They have not complied with the statutory duty. So we are going on to the next step of what happens when they do not comply with the statutory duty to either release the goods to you or to defer to a magistrate. Now let's look at some of the legal remedies that you may have in the event there is a seizure and there is no prosecution and there is nothing you can do. Your goods are just sitting there in the port and you don't know what you can do. So let's see what you can do. Okay, if you have reasonable grounds to believe that the seizure has no reasonable or probable cause, what you can do is you can file a claim at the High Court. Okay, so usually this is done based on the value of the goods. If the value of the goods is more than 1 million, you can file it in the High Court. If it's less than 1 million, you can file it in the Sessions Court. So anywhere between 100K to 999 and 999K, you can file it in the Sessions Court. But if you are very certain, based on your documentary record, based on your documentary evidence that whatever is seized is more than 1 million, obviously you have the right to file in High Court. Okay, so when you file a suit in the High Court, you have to firstly name the correct parties. So firstly, when you are naming the correct parties, in most cases you would file it against the seizing officer, because you want to know from the seizing officer if there has been reasonable or probable cause, because the seizing officer is the only person who can give evidence as to why he thought these goods must be seized. He must have thought something is wrong with these goods, whether they did not come with the permit, whether it was sitting in the port for too long, or whether he received some sort of confidential information that something wrong is going on here. So he has to explain why there was this reasonable or probable cause. Okay, then you can name the investigating officer. As I mentioned earlier, the seizing officer will just seize the goods and then pass it on to an investigating officer who will then conduct the proper investigations. So this investigating officer is the one that will be in charge of taking the statements, taking the documents, looking through whether there's an actual case here that he can take. Then you also have to name the relevant department. As I mentioned, there's different departments in customs. There's bahagian klasifikasi, there's bahagian penjenesan, there's bahagian pendakwaan, there's enforcement, there's operasi, there's many types of different departments. So you have to name the relevant department. Then obviously you are also going to name the Royal Malaysian Customs Department as a whole, because they have seized something and they have kept it unlawfully. And as government agents, you can also name the government of Malaysia as a defendant in this suit. Generally, in a claim against the customs officers, or the Customs Department, you can have a prayer that includes a declaration that the seizure was unlawful. So what do you mean by seizure is unlawful? As I said, remember earlier in my talk, I said that there's a 30-day period from the date of the notice of seizure for you to apply for release of the document. Then from that day where you serve that notice on the customs, there is another 30 days within which there must be a decision by the DG of Customs whether to release the goods back to the owner or to commence prosecution. So this 60-day period is a very important timeline, and if nothing is done in these 60 days, what we call an unlawful seizure has already taken place. Okay, so what that means is I don't need to wait any more than these 60 days to know that something unlawful is being done by the Customs Department. Okay, so you can pray that a declaration of the seizure was unlawful and the continuous seizure remains unlawful until the day either damages are paid to you or the day the goods are released to you. Following that, there can also be a prayer that damages be assessed and also for the goods to be returned. So now the damages to be assessed is something that you have to be wary of. I will show you why. Okay, so in this section 114 of Customs Act, it tells you that in respect of any entry or search of any premise, place or conveyance or seizure of any goods, books, records, documents, you cannot be entitled to the cost of such entry, siege or seizure or to any damages arising from the search or seizure that was made unless the search or seizure was made without reasonable cause. So if the first thing you have to prove when you want to get your damages from Customs Department is to prove that either the search or seizure was unlawful or it was made without reasonable cause. So just because this section exists doesn't mean you cannot claim for damages. You can, but there are additional steps that you must satisfy. In the same light, or almost in the same words as well, Section 132 of the Customs Act also says that you cannot in any proceedings before any court in respect of seizure of any goods. So you see how the words are very wide. It always says any proceeding, any court, any goods. So it says here that you shall not be entitled to the cost of such proceedings or to any damage. That then comes the caveat, other than an order for the return of such goods or the payment of their value, unless such seizure was made without reasonable or probable cause. So there is a case that we will discuss later on that shows that upon successfully proving that a seizure was unlawful, you are automatically entitled to the return of the value of the goods. To the damages or the payment of the value of the goods. So just say that you don't want the return of the goods because maybe they have already spoiled. By time you file the suit, there's a lengthy trial process, and then you finally get your order. But when you finally get your order, please bear in mind that there is a twofold appeal step. So if you get an order in the High Court, they can appeal to the Court of Appeal. Once they exhaust the Court of Appeal, they can also appeal to the Federal Court. Just give you an example. Maybe 5 years has passed from the time you file the suit to the time you win your case. At the end of these 5 years, if you had ordered beer, the beer will spoil in 3 years. There's no value for you to seek the return of the goods. So what do you do at this point? You can seek the payment of the value of the goods. So then when you get the court to assess your damages, what the court will do is they will see if you can prove the value of the goods. So if in 2020, say 5 years ago, in 2020, you brought in goods that were worth 1 million or 1.5 million. So you have all your receipts, you have all your payment vouchers, you have your bank slip that shows a transfer of 1 million to a consignor, and you have brought in that goods here, and out of nowhere the goods are seized. And there was actually no probable cause in that seizure. And not only there was no cause, they also didn't comply with your demand for the release of the goods. So upon having the court order or declared the seizure to be unlawful, you are automatically entitled to have this 1.5 million that you paid back in 2020. Okay. So I will explain the case later, which talks about how to assess the damages. So now let's move on to some of the key cases that are involving the Customs Department overreach and what we can show from the recent judicial. So this case of Sun Tzu versus Jabatan Custom Diraja Malaysia. This is quite an old case from 2010, but what I know is not the first case. There has been preceding cases, but this is one of the most used cases every time we look at customs overreach, right? So these are the brief facts of the case. On 5th September 2008, the plaintiff and 2 others were arrested by the police near the Malaysian-Thai border with 9 buffaloes loaded on the plaintiff's lorry. So once they are caught by the police, what the police did was they said, this is not our jurisdiction. They passed it on to customs, which is why you say they are arrested by police, but they are suing the Jabatan Custom. Okay, so there's a little bit of info here that I've omitted to keep the story short and sweet. So the plaintiff then claimed that the buffaloes were legally purchased at 1,600 each. The plaintiffs then received a notice of seizure alleging that an offence under Section 135 and 133 of the Customs Act has taken place. So 133 and 135 is usually non-payment of duties. Okay, but they received the notice of seizure alleging that there's an offence been committed, but in the end of the day, nobody was charged in court for this alleged wrongdoing or alleged offence. Okay, so the plaintiff submitted 2 statutory duty declaration claiming the return of the seized buffaloes, which the defendant denied, and then the defendant also failed to refer the matter to the court within 30 days after receiving them. So what did the High Court say in this case? The plaintiff argument was centered on the failure to refer the seizure matter to the magistrate within 1 month. So remember earlier, if you can recall, I said that there is a 30-day period that you have to put in the claim where you're claiming the release of the goods. So in this case, let's go back a little bit. You can see at the bottom there, the plaintiff had submitted 2 statutory declarations claiming the return. Okay, so they have done that. They have done the first part. They have complied with the 30 days. They've done the first part of claiming the release of the goods, right? Then what happens is that the customs didn't do anything with that notice. So they didn't release the goods, they didn't release the buffaloes, and they also didn't refer the case to a magistrate, which is required of them under Section 128. So the court here, in this case, Suntara Raju Pachiappan, the court found no evidence that the plaintiff's claim was ever referred to the Director General within or after 1 month of the receipt. So here we go. Now what the court said, you received within 30 days, but you didn't take any action on it. How can this be lawful? Because what does that mean? That means the Customs Department can just keep your goods forever. No action needs to be taken. Nothing needs to be done. Is that lawful? I hope not. And the courts are with us on this, right? So the courts have decided that no, the Customs Department cannot forever hold on to your goods, right? So there is a timeline to be complied with, and there is now a very strict application of that timeline. Yeah, the court here found that there was no decision made by the Director General, but come on, there was no evidence of the claim ever being referred to the Director General. So how can there be a decision? So it's a consequential failure here to observe the statutory duty. So because there was no evidence the claim was referred, and then there was also no evidence that there was any decision made either to release the goods to the plaintiff, and the goods here we are talking about buffaloes. Yeah, how long do you think you can keep buffaloes? Not long. Okay, because what's going to happen? Who's going to feed the buffaloes, right? You have to be sensible, you have to be logical about these things. So this is why the timeline applies, because not only you are dealing with livestock, you are dealing with perishable goods. Sometimes you are dealing with fast-moving consumer goods, which are very perishable, like bread, okay, bread or milk or things like that. Meat, how about meat? Frozen meat, you cannot keep frozen meat for too long, because whether they are frozen or not, they will perish. They will eventually perish. Okay, so the court in this case decided that the Royal Malaysian Customs Department had failed to comply with the provisions of Section 128, subsection 3, in that the Director General of Customs has to make a decision whether to release the goods or to direct a senior officer of customs to refer the matter to a magistrate for the magistrate decision. So the court agrees that the decision to refer the matter to the magistrate must be made within 1 calendar month from the date of the receipt of the notice of claimant. So remember, you had first, from the date of notice of seizure, you have 30 days, right? 30 days to put in your claim. So this case says that a decision to refer the matter to the magistrate must be made within 1 calendar month from the date you sent in your notice that you are claiming the return of the goods. Yeah. So this case was in 2010. And we'll now move on to a later case, which was decided in 2015. So maybe that was an interesting case. The appellant was stopped at KLIA while attempting to leave for Iran with $350,000 in his briefcase. which he had failed to declare or obtain approval from the Bank Negara Malaysia. He was therefore suspected of an offence under Section 135 of Customs Act, again failing to declare duties, and the Exchange Control Act 1953 for carrying uncustomed goods. Okay, a notice of seizure was signed by the senior customs officer who had effected the seizure, and immediately after the seizure, please note this, the same senior officer of customs who had effected the seizure of the cash monies interviewed and recorded a statement in writing from the appellant. So what did the appellant say in this statement? Basically, there was no written statement, written notice here, no written notice that he is claiming for the USD 350,000, either via his own or his lawyers. There was no claim made, and his reason for carrying the money was, as stated below, the money was to purchase a home under the My Malaysia Second Home Program. Okay, this matter went all the way to the Court of Appeal, and the Court of Appeal decided that we are of the view that there was a substantive compliance with Section 128, Subsection 1, Subsection A, and Subsection 2 of the said Act. So what Subsection 128, Subsection 1, Subsection A requires you to do or states is that when a goods is seized and there is no prosecution, the goods are to be deemed forfeited unless you satisfy the earlier provision that you have already claimed for the return of the goods, right? So as long as you comply with it, you will then move on to subsection 128, subsection 3, which is where the DG of Customs has a decision to make. Remember the two decisions we spoke about, which is either to release the goods to you or to refer to a magistrate. So in this case of Medi Dadashi, even where there was no written notice to claim for the return of the 350k, the court was of the view that in his written statement, let's go back here a little bit. Okay, see that the seizing officer had interviewed and recorded the statement, right, from the appellant. The court was of the view that his recorded statement was sufficient to inform the customs officers that he is claiming for the return of the money. So it is not required for you to have it in writing. You can also say it by way of a statement, recorded statement. You can see the highlighted section here. We conclude that the written statement recorded by the customs officer suffice as a written claimant for the return. So having concluded that there was notice of a claim for the return of the 350k USD, it follows that no automatic or deeming forfeiture of the monies would follow. So once there is a claim, there is no deemed forfeiture, right? Even if there is no prosecution, there is no deemed forfeiture as long as a claim has been. So in the case of Medi Dadashi, the Court of Appeal concluded that the appellant did make a claim within the purview of Section 128, Subsection 1, Subsection A, and the respondents were bound to refer the matter to the Director General, who in turn had two options again. Let's recall what are the two options: to return the money to you or to refer to a magistrate. So the court in this case, because that was not done, they found that there was failure to comply with Section 128, Subsection 3, and they ordered for the money to be released to the appellant in this case. So in this case, it makes sense for you to return the money because money is tangible. 350k, if you had seized it 10 years ago, it's still going to be 350k, if not more valuable right now. In this case, it made sense that the money was to be returned, or the equal value or the payment of that same equal value is to be made by the Customs Department. But in cases of perishable goods, there is no point for you to request or even pay for an order for the return of the goods, because even if you get it back, you cannot sell it anymore. Your economic loss has already occurred, right? So there's no point for you to claim for the return of the goods. Now let's go back. Now let's move on to the case of Modern Freight Express. This case was something that I personally did handle in 2017. So let's run through the brief facts. In September 2015, the plaintiff was appointed and instructed by 6 different consignors to take possession and to manage the declaration, clearance and shipping of the consignment of beer and apple cider. So these are the goods. So in November 2015, the plaintiff was informed that all 40 containers were seized. So I will highlight here the issue of the delay in declaration. So the goods arrived in September 2015. The declaration was only made in November. So there was almost a 2 months delay, and this had already raised reasonable suspicion for them to seize. So even if they had reasonable suspicion, that doesn't allow the customs officers to make an unlawful seizure. So what makes an unlawful seizure? An unlawful seizure happens when you make a claim on the goods and there is no decision made on that claim to return the goods or to refer to a magistrate. That, ladies and gentlemen, is the unlawful seizure that we are talking about here. Okay, so the plaintiff, through its solicitors, made a claim to the state director pursuant to section 128 subsection 1, demanding the release of the goods. So in this case, we demanded for the release of the goods because it was very close. So between September to November, and then in December, there was an application made to demand the release of the goods. So if nothing happens between this time, obviously this beer and apple cider is going to perish. So by the time this case came up to the court, it was already 2017, right? So there was already 2 years lapse, and there is no point at this time when we filed the suit to actually file for return of the goods. In lieu, I think what we did was to have the damages assessed by the High Court, and the damages were assessed based on the proof of receipts and payments that were made by the consignors. So the decision of the Court of Appeal, this matter was unsuccessful in the High Court. The High Court was not with us. They actually said there is no unlawful seizure and they dismissed the plaintiff's claim. But on appeal to the Court of Appeal, they found that there was, on the basis that the appellant was not which means the proprietary owner of the goods. So the Court of Appeal overturned the High Court decision and said that there is no merit to the averment that the appellant must be the proprietary owner of the goods. Okay, they said that the words asserting that he is the owner in subsection 2 of 128 were wider than lawful owner. So I did not put it in, but the definition of lawful owner is found in section 2 of the Customs Act, and it actually includes anyone who is an appointed agent of the owner of the goods. So in this case, they tried to be funny. The Customs Department tried to say that, it's not the consignors who are seeking, it is the plaintiff who is seeking. The plaintiff is just an agent. He does not own the goods. So in this case, the Court of Appeal had reversed that position and they said you do not need to have proprietary ownership of the goods so long as you can claim the goods as an agent. Okay. So moving down, the court held where the written claim was made by the appellant within 1 calendar month from the date of seizure and no prosecution had commenced in respect of the goods within the same period. Then on the expiration of 1 calendar month from the date of notice of claim, the respondent should release the goods or refer the claim to the magistrate. Okay. This position was then again tested in the case of Sarmina Sendirian Berhad versus Gary Ho and others. In 2023, I also had the same pleasure to handle this matter, and in this case, we went all the way to the federal court. So basically, the brief facts are as stated here in this slide. The appellant, in its capacity of the agent of the consignors of 17 containers containing liquor, which were seized by the Customs Department, had brought an action for a declaration that the continuous seizure was unlawful and invalid, and for special, general and exemplary damages to be assessed. Okay, the High Court found that the appellant's ownership of the goods and the letters from the appointing the appellant as agent were doubtful. As such, the court held that the appellant had no locus standi to bring the claim to the... So premise on this same finding, the High Court dismissed the appellant's claim and the Court of Appeal had affirmed the decision. Then we had the chance to take the interpretation of Section 128 of Customs Act all the way to the Federal Court. So it was decided in the Federal Court that Section 128 provided all seized goods where there is no prosecution and were deemed to be forfeited after 1 month from the date of seizure unless the existence of the facts stated in subsection A, B or C exists. So this means there has been a claim made by the owner. Okay, if there was a claim under Section 128 subsection 1 subsection A as alleged by the appellant, the claim must be referred to the Director General, who then had two choices, either to release the goods to the claimant or refer the matter to a magistrate for a decision. In this regard, pursuant to Section 2 of Customs Act, an agent was considered an owner who may claim for the goods under Section 128 subsection 2. So in this case, the Federal Court also found there were uncontroverted facts that showed the appellant was indeed the agent of all the consignors of the 17 containers. So the court then found that the non-consideration by the trial judge on section 128 of the Customs Act had prejudiced and caused miscarriage of justice to the consignors. In addition, there was a finding that the appellant had no locus standi, but this was against the weight of the evidence. Okay, so the federal court then held that both the High Court and the Court of Appeal decision was plainly wrong, and intervention of the federal court was warranted. So what was the effect of this Sarmina's case in the federal court? Let's move on to this latest case of AGM Duty Free bin Ishak and others, which was decided very recently in 2025. So this case, again, the backstory had started in 2022. The customs had seized 2,400 cartons of beer from the appellant's premise and from its lorry on suspicion that an offence has been committed. However, as you may have guessed it, no prosecution followed. So what happens if there's a seizure and there's no prosecution? Yes, you are right. So within 30 days, there must be a claim on the goods. Okay, so in October 2022, the appellant sent the respondents a notice claiming for the return of the goods, and there was no response. Surprise! So on June 2022, the appellant after nearly 9 months, the appellant through its solicitors notified the respondents that it would take legal action if the seized goods were not released. So on June 2022, when there was a threat of legal action, that is when the investigating officer wrote to the appellant stating that investigations had been completed and that consent to prosecute had been obtained. So the decision of the Court of Appeal in this case, I'm not surprised to say that the plaintiff was not successful in the High Court. So then they had to appeal to the Court of Appeal. And in the Court of Appeal, following the case of Sarmina, the court decided that the respondents who did not commence any prosecution against the appellant within 30 days of the date of the notice of seizure as required under the Customs Act, and neither did they refer the plaintiff's claim to the court for an inquiry upon expiration of 30 days from the date of the appellant's claim. Okay, so they said that the respondents had a blatant refusal to comply with the law, rendered the seizure wrongful and unlawful, entitling the appellant to damages. Right? So the decision of the Court of Appeal was that the High Court erred in holding that there was no time frame under Section 128, subsection 3 and subsection 3A for the seized goods to be released or to be referred to the court on the expiration of 30 days. So what this case means is that it is fortifying the fact that in 30 days there must be a prosecution. All this while, they have been trying to flout the process by saying that there is no requirement to start a prosecution within 30 days. The effect of the case of Sarmina and now the effect of this AGM duty free is the fact that the Court of Appeal has confirmed and solidified the timeline and the process that there must be a prosecution within 30 days. Okay, so the court held that the High Court had misconstrued and interpreted Section 128 of the Customs Act and had failed to follow the decision on the point in Sarmina, which is the case we referred to earlier. Okay, and then in this case, there was also a very interesting decision that the court had ordered a prosecution to be instituted. So on appeal, the Court of Appeal found that the High Court had violated Article 145 which usurped the prosecutorial power of the AG, because the power of the AG to institute and to initiate prosecution lies solely with the public prosecutor. It is not for the court to order by when you should prosecute somebody. So the court also found that there was a violation of Article 145 in this case. So we have come to the end of our talk, and basically what this says is that not only a forfeiture is deemed unlawful when there is no reasonable cause or no probable cause, what I would like to emphasize here is the fact that a continuous seizure with no action taken by the Customs Department in itself constitutes an unlawful seizure. Right? I've come to the end of my talk. Jet, I think we can see if there are any questions.
Thank you so much, Mr. Gala, for your insight. I believe it captures very well the overall process and the powers of the department, and also the practical steps which I believe could be useful to any of our participants who are business owners within this industry, and also to those poor buffaloes. Okay, now we'll move on to our Q&A session, which I believe there's a lot of burning questions here in the chat. So yes, I'll just read out some of the questions, so maybe Ms. Agalia can address to those. So the first question that we got is, can insurance or indemnity arrangements realistically cover the financial impact of such unlawful seizures?
This is an interesting question. I have not addressed the issue of insurance or indemnity, but yes, thank you for the great question. In what I would say is no, and my answer to the question is no. Insurance will usually not be triggered due to the seizure by a governmental department, in this case, a customs officer. I believe that parties will have to bear all the costs, including daily demurrage, which is a charge payable to the port or shipping agent. So most of the times, Howjet, I think containers itself, like those big containers that you see being transported here and there, they do not belong to the owner of the goods. The ownership of the containers themselves remain with the shipping liner or the shipping agents. So having this container as a whole seized by the customs department means that the goods inside are stuck with the containers, right? So the person who has goods inside has to be responsible for the payment of the demurrage of those containers as well. So I don't believe that insurance will kick in or indemnity will kick in at any point. Yeah. So the containers are still subject to daily charge by shipping agents or liners who own these containers, and whoever has goods inside will have to pay those charges.
Okay, thank you so much for that. So I believe there's some few other questions with our participants. So I think one of it is, do these custom officers need warrants before searching in that sense? Or in terms of searches of premise or vehicles, etc.?
Okay, so no, they do not need a warrant. But in the event that they do need a warrant, they can obtain one from the magistrate. But most of the times, a warrant is not required because there is a real threat that some sort of evidence, documents, or even things on laptops and computers and phones can be deleted by the time they go and get the warrant and come, and then all the evidence is gone.
Okay, I believe we have time for one last question due to the interest of time. So yes, another one from the chat, which is, the 30 days timeline is very strict and important, but can we still challenge the seizure after the 30 days rule on procedural irregularity or non-compliance by the customs officer via either judicial review proceedings?
Okay, so the 30 days rule is, of course, it's very important. Firstly, if you know that a seizure has taken place, then it applies. But if you are the owner of the goods and you do not know the goods have been seized, you can still have a chance to file a suit or take a claim on procedural impropriety. Required to go through a judicial review process for this. I think it suffices if you file a writ action. Yeah, because to overcome the leave stage of judicial review is equally as hard as and challenging.
Yeah.
So let's work around not going through a judicial review. There are other options.
Okay, I think that's all the time we have for today. So I think I'll wrap up on the Q&A session. But before we conclude, I do have a few announcements that I would like to share with all our participants here today. So first of all, please feel free to join us again for our upcoming talk. We'll be having one again next month, around 29 November. At this time, our topic will be on medical negligence. And this will be carried out by our medical negligence team, and it will be in Mandarin. So if you have any Mandarin speaker friends that are interested in this topic, do feel free to share with them, and also do sign up as well. Now, secondly, please also fill up our feedback form. We will be happy to see if there's any feedback on where to improve, or you can even drop down what topic you want us to cover next.
Yet before we end, I would just like to inform the attendees, if you have any questions that you have raised which we have not covered here, perhaps what you can do is reach out to the firm and we will provide you with a 30-minute free consultation, which I think you can expand on that, Howjet.
Yes. So yes, on that as well, our firm has the free 30-minute consultation as mentioned by Agalia. So if you have any questions of all, it's complimentary. First of all, 30 minutes. It can be over the phone or video conference. So all you have to do is just fill up our Google form here and we can schedule for that. Also, before we go, please feel free to follow us on our social media. On YouTube, we have all our previous videos uploaded, and also our social media platforms will have all the updates of upcoming talks and information that you might need. So I believe that's all. So to all our guests, thank you all for joining us. We hope that you found today's session informative and useful. And thank you, everybody. See you on the next talk.